Kizza Besigye.
They have never been system. They have never been strict. That's why we are coming before you. Those facts I must emphasize are not mine, they are contained in paragraphs 4 and 5. Statement of paragraph 4 and 5. Your Honor, the duty of the Africans from the house of mandatory aid rests primarily upon.
Just I think this is just overwhelming copy. My colleague is simply overwhelming copy.
Before I was interrupted, I was informed in the talk, in fact, that even if the applicant has not applied, even if the applicant has actually not applied, that's not a prerequisite for mandatory pay. The application for mandatory pay is not a prerequisite for mandatory pay. The prerequisite for mandatory pay is the infraction. The infraction of 180 days for capital offense. It's not an application. It behoves the judiciary, but specifically the trial magistrate, one, to count the days, to be aware of how many days the accused before that person has spent on remand. And as soon as they clock 180 days in the case of capital offenses, pursuant to section 76 that has already been alluded to of the Magistrates Court Act, the magistrate can simply release. It's as simple as that, although some people want to complicate it. Now, Your Lordship, if the magistrate does not want to release the applicant following the parent law, there is subsidiary law called the bail guidelines. Because for me, there should not be between the conflict between parent law and subsidiary. But in case the magistrate has any doubts about what to do, they should follow regulation 10 of the bail guidelines and immediately refer the file to the High Court. And once that file is referred, again in sub-regulation 11, the registrar of the High Court, of the Criminal Court, which the matters are referred, is obliged, not requested, is obliged by the bail guidelines to schedule them, and of course mindful that the court should resolve the matter within 30 days. The reason the magistrate is assumed to know the remand days because every remand, Your Lordship, happens under the remand warrant. Every remand happens under the remand warrant of the judicial officer and before committal, specifically of the magistrate. a magistrate cannot feign ignorance that somehow I did not know that the applicant before me, they are choosing before me, has not spent 180 days, because every mention they have to be aware of how many days that the choosing person has spent on demand before further committing them on demand. Your Honor, is the argument of the state that they are about chance. The reason they object, one of the reasons they object to the mandatory bail, which is an unconstitutional reason, is chance, press conferences, and chance and press conferences. I want to say that those are constitutionally protected rights under Article 29. And the third reading of Clause 1, Article 29, would preclude the state from citing it as a ground of objection. A related objection, Your Lordship, is that the paragraph 29 of the reply, and it says that the accused is of a high profile, paragraph 29 of the affidavit of who conducted the scene. The reason is that the accused are high profile, influential, and command a big following. Your Lordship, few statements are astounding as this in the journey of the legal profession. So you are being invited on record in writing, Your Lordship, that you stop the bail, the liberty they are choosing, simply because they are high profile, influential in society, and command a big following, and they have the audacity of including this in the sworn testimony and filing it on the record of the High Court. Your Lordship, high profile popularity is not a ground for denial of liberty, even if you are not mandatory bail. I think it is regular for the state to be envious of the accused. The point of liberty has been just very clarified, but one of the fundamental points of mandatory bail is actually to stop trial without detention. Detention without trial. And these are not my own words, these are the words of the Constitution. And the Constitution adapts them in the Article 43. The twin purpose is prevention of political persecution. Again, Article 43 sustains there and expressly outlines that. It is a factual reality that the accused are being politically persecuted. Although it goes without saying, the accused have taken responsibility to outline it in paragraphs 3, rather paragraph 30, paragraph 30 from their affidavit. Paragraph 13 of their affidavit talks very clearly about the political persecution that the accused have had to endure. And unless the state is saying that it defied the Supreme Court decision and it did not transfer the charges, But of course, the facts will betray them. Your Lordship, what changed was only the courts. The fact of remand itself has never changed. Howsoever, forever, the charges that were in the court martial are still here by order of the Constitutional Court. The idea is that the facts are the same, have not changed, and the law is on the principle of legality and double jeopardy does not allow. It's not even that the state can now introduce new facts. The law on the principle of legality and the prohibition of double jeopardy that's contained in Article 28 of the Constitution does not allow twisting facts so that on the basis of the same fact you bring a multiple charges, you keep tinkering with the nature, the legal nature of charges while you're using the same fact. That is not allowed. And in any event, it would have been prohibited by the order, express order of the Constitutional Court. So the accused, all the applicants have been remanded by 4 courts. The first court to remand them was the Kampala Military Tribunal, 20th of November 2024. Following the Supreme Court judgment, the applicants made an application to the High Court Civil Division for habeas corpus. They argued it. And on one of the versions, they argued it, I was there, the trial was from the superior. Yes, so they were remanded by that court. Even before their ruling on habeas corpus was given. Then they were remanded by a magistrate court in Kampala, and then they were remanded by the criminal court, the criminal division here. That is the case of reality. Most of that, I will leave the floor to my colleagues.
Politician here.
My lord is not for a discretionary bail. And indeed, my lord, the bail we are seeking, today the applicants are not here for a right to apply for bail. But rather to receive a bail, my lord. That provision was deliberate and intentional by the framers of the Constitution of 1995. Deliberate and intentional. It was premised on, among others, the oppressive and imprisonment without trial which was characterized, which characterized our political history, my lord. My lord, denial of the right to a mandatory bail by the applicants now before you will be so detrimental to the values and wishes the framers of the 1995 Constitution intended to achieve, my Lord.
Number 31 of 2025. As the applicants, we are seeking a right of habeas corpus. My Lord, I just want to go through this briefly. Just right from the argument. My Lord, a copy of the same is here and we have actually highlighted. That is retired Colonel Dr. Kizza Besigye and Obedi Vice Attorney General and the Commissioner General of Prisons. Those of the parties. My Lord, my senior colleague, Honorable Major Sebona, as it is, submitted as below. That the transfer, that is true, the transfer of the General Court Martial files to the DPP and the civil courts is legally impossible. Since that court had no power to try the applicants in the first place. Just for emphasis, my Lord, what about here, my Lord, is my submission. Is that the rationale of that is that whereas the UPDF and the General Court Martial fall under the military justice system, the civil courts fall under the civil justice system. Bundling the two would be a legal error. As if that's not enough, my Lord, my colleague, my senior colleague, Honorable Major Sebona, continued that the Supreme Court did not order. He going to submit that the Supreme Court did not order the DPP to take over the GCM files, General Court Martial files. Because doing so would infringe the constitutional provisions
in brackets under prosecutorial powers of the DPP. My Lord, that view was also echoed by Mercy Makoto Lord Mayor Elias Rukwa, Council for the Applicants. Now, in that application, my Lord, allow me quote directly and quote verbatim what the judge had to say. He said that, as understood by this court, the applicant's position is that to the extent, and my Lord, this is on page 10, that to the extent that the Supreme Court decision nullified the power of the General Court Martial, GCM, to try them. They remain in legal detention. Because they are no longer lawfully detained by the prison authorities. And no longer lawfully detained by the prison authorities, and cannot remain in illegal detention. On account of the uncertain administrative processes that seek to implement the Supreme Court decision. Besides, all previous cases before the GCM, the General Court Martial, had equally collapsed. And could never be resurrected by the DPP. Because, my Lord, this is very interesting. Because doing so would be constitutionally improper. Further stated that under Section 56 of the Evidence Act, Cap 8, Section 56 of the Evidence Act, Cap 8, this court is enjoined to take judicial notice of the proceedings of 21st February 2025
So the idea about interference is really a fiction. The law requires the state to prove what it is saying, and it has not done so. That says they are associates, unnamed. It sounds fictitious. They are witnesses, unnamed. It's likely they don't exist. As I close my last submission, it's about the question of abuse, the alleged question of abuse because of multiple applications. Well, first of all, there are big three applications. Which are about liberty, but not amount to abuse of this court's process. And the remedies sought are different, or they are differently provided for. Today we have argued mandatory bail. These circumstances, as we have been hearing, are different from discretionary. This one was filed on the 28th of May 2025 at 7:41 p.m. On the 22nd of April 2025, that one was in the morning. The one which we have a tendency to have today was filed. That one was for discretionary bail. Note there are different applications. The circumstances are different. The one that is pending for another of your brothers is a revision application. It's not about and all these are weaknesses for your children. It's not hard to check and see what they are about. But for somebody to say that if you file 2 applications seeking liberty, personal liberty, you are abusing the processes of this court. It's quite shocking how an unfriend could equate that pursuit for personal liberty with abuse of this court's processes. Surprising. Maybe I would have taken him seriously. It hadn't been for the fact these applicants have been imprisoned for 463 days. So if you are not dealing with people who are in prison, maybe I would have taken you. At least one of the was being funny. But this fact of 264 days, 63 days, brings me to a whole different dimension of why these objections are being made and what the intentions of the state are. My learned friend is suggesting, my Lord, is that we should go back to the days before the constitution that we know now. Because it hasn't always been the case that there was available. We had a number of laws in our books in the past. I may just cite 3 of them alone for historical purposes. Detention and Removal of Undesirable Persons Act, that was 1960. Detention and Removal of Undesirable Persons Act. We had the detention decree in the 1970s. Then we had the Public Order and Security Act in the 1980s, where detention was unlimited. My landlord is suggesting that we should go back. Lord, I urge the court, looking at this vision of justice for all, to grant these applicants the remedy they deserve. A remedy which the Constitution has given them. Because as we heard earlier in the morning, my Lord, next to life, personal liberty is the next most important human right. What is critical is this number of days of detention. The number of days of detention currently at least. Although doesn't say start counting when the DPP becomes interested in one matter. It says when you are charged. My young friends may have one or two other things to promise. And I'm going to go on to the
Most of them may wait, and it will be very brief because most of the issues have been touched. I want to reiterate that this is an application for mandatory bail, where it's been stated that the conditions are different. My Lord, to that extent, the decisions cited by the Chief State Attorney are not relevant because they relate to discretion of the true to his side, and we have in the lower courts. Finds it easier to mislead court that this is mandatory and not discretionary. So those decisions you're referring to will be kept, perhaps, application PH2 for 2020. My Lord,
we do take things for granted because we are with the DPP. But now we shall not. Now, in Article 250 of the Constitution, legal proceedings by or against the government. Paragraph 4 reads, in the title of any criminal proceeding, the prosecution shall be designated as Uganda. In the affidavit in that application, which was drawn by the office of the DPP, the deponent would get benefits in paragraph 3 and 4. Paragraph 3 and 4 starting. Uganda versus the Africans and the one Captain Dennis Ola. My Lord, we are going to take the court record. He says the respondents were previously charged before the General Court Martial and were being tried there. However, following the decision of the Supreme Court in Constitutional Appeal number 2 of 2021, it's an affidavit which my colleague was writing. But in paragraph, my Lord said that from the decision of the Constitutional Court number 2 of 2021, Attorney General versus General Michael, the case was transferred to Uganda Police Force. My Lord, was Mr. Bill arguing that application, alleging the transfer. The man who people to stand by their work in the night or in the day. And I look in paragraph 4. The people says the Uganda police took over the investigation on the 11th of February. And I was one of the officers assigned to investigate. So my Lord, we should point out the economy of the truth Mr. Bilbunka is exhibiting. The matter was with them because they took over. So it is the same process we are talking about. My Lord, my last friend also referred to abuse of process. When we tried to tell him what Bill Davis from the back, he said he was submitting. My Lord, I want to bring some material facts to your attention. So, go to this. The state was represented by Deputy Assistant DPP Lino Kwanguzu and a one Richard Billy Kumbuka. And Mr. George Bigia, the third gentleman. And already the conference it was agreed that the amendment in that application touching on mandatory bail be removed. We agreed with this bill. You are there. Unless you are with this bill. So it is a lie for him to say that that application is seeking a relief bail. You can tell a lie when you submit, but it is under pressure. So my lord, the applicant, as my colleague Mr. Rivera said, these applications, my lord, they are filed a month apart, and the question, my lord, which has taken us the whole day, is why are we here today? And why I ask that question? Because in the criminal proceedings in Nakawa, when the accused were charged, the applicants, up to COMITED, there was never any new evidence brought to the court, brought by the state. My lord, ever since their arrest and detention in November, we haven't recorded any new police statements to the applicants. It is the same process. So why are we here? Lord, we are here, and I'm going to mention them because my brothers, Mr. Jashiko and Mr. Besigye, were with us in Macau. So we are here because ever since they took over proceedings, they slept on their singular duty which they do every day to commit. They did commit in 180 days. They woke up after the application. And they want to believe that the applicant should be responsible either for their inefficiency or incompetence. That is wrong. What is the job they are facing? So that they did not do it, which triggers the right to be brought by the applicants. They cannot stand in the way and use this court.
It was never prosecuted until the Supreme Court, yes.
We just look at here. We are set by the TP or the court
You can't enlisted the case. The same charges were reinstated. This time around in the General Court Martial. And Besigye was never tried until the Supreme Court decision in the Kampala. Then there was no transfer of the case as directed by the Supreme Court. Besigye goes to High Court and asks for mandatory payment. Then the court took time to took trouble to compute the time of remand. They counted the days right from the time it was charged in Uganda. That's how the computation was done. And it's on record here. By the time he was granted mandatory bail, he had brought 1,500 days of remand, including the time he was charged in Uganda and the General Court Martial. And by the time he was granted mandatory bail, following the Kampala decision, the charges had not been transferred in the civilian court. They were still before the General Court Martial. No, he hadn't even been charged because the charges were still before the General Court Martial. notwithstanding that there was an order of the Supreme Court that transferred those charges. So court took a decision, Justice Moore took a decision and said, we are granting you mandatory bail because you have been incarcerated illegally beyond the mandatory period. Now, Mr. Vumbuka is inviting you to set aside that decision. Very, very strange that you pronounce this decision Babylon. When actually Besigye is already out of bail. So when you pronounce yourself that it is Babylon, will Besigye again be arrested? So, my Lord, this is the compelling decision in this matter. The judges say here they want to conclude. In Attorney General versus Honorable Michael Kavasuduka, the Supreme Court held that military courts lack jurisdiction to and ordered the transfer of such cases to civilian courts. The court emphasized that the jurisdiction of military courts is limited to members of the armed forces and offenses under military law, neither of which applies to the civilian charged with civilian offenses like murder. Following that order from the Supreme Court, there is no evidence from the prosecution that the applicant's file has been transferred to the civilian court as ordered by the Supreme Court. The applicant, the civilian charged before the General Court Martial, in proceedings subsequently declared illegal by the Supreme Court, has been on remand for over 1,500 days. There is uncertainty as to when his file will be transferred to the civil courts, and that his continued detention is a violation of his rights. So that basis that he gets mandatory. My Lord, why I'm emphasizing is that this court has pronounced itself on the transfer, on the Texas. And finally, on that particular matter, I think it took this decision literally. The transfer by the Supreme Court did not mean or presuppose physical carrying of the files from the General Court Martial to the civil courts. Transfer of charges that terminate the proceedings the other side, then continue with the prosecution if you have reason to do so in the civil courts, civilian courts. That's what it meant. It didn't mean actual transfer, because you know, my Lord is on record under Article 20. The DPP could not actually get those files, the actual files from the General Court Martial, and continue with the same here. So, it shouldn't have been taken literally. So, on that basis, my Lord, we invite you to find that there is a nexus between the proceedings before the General Court Martial and the current proceedings, and the computation of time of remand should start from the time they were ordered to be remanded by the General Court Martial. That was held back on 28th November 2024. Then there are charges, there are other cases he made in person. This just in passing, my Lord, that by the time Dr. Wesley was granted bail, rather he alleged to have committed his offense. That time he was on bail in the case before the one of 2023. My Lord, I would invite you to check the system. There is no such of case of 2023. It's not there. At least I can speak authoritatively as a lawyer in those matters. There was one of 2022. If you wanted to make a reference to that of June 14th June 2022, that would be a different matter. But any case or a case filed against Dr. Besigye in 2023, and Moka, it's not there. So you can check in the court system, maybe you have influence and cross-check with these facts. My Lord, in wrapping up, we are grateful to you for the time you have afforded us since morning. I'm only imagining that court has not even had a greater break. We really appreciate this. same vein that we use, the same spirit and vigor, stamina, my Lord, and finally, my Lord, the submissions made by my lovely friend here should be expanded. The ones which were sentimental and emotional, about Bill Mukawida, he was arguing out his own case. He was not arguing out the state's case. Those should be expanded. Tonight, my Lord. We are available to the direction from the school. Whatever can be. Yeah.
Because we are just here, interest of time.
Our prayers are the expectations.
That's what
My God, we can even have a ruling now. Reason is later.
Just consent now that by email, other conditions will come.
That's
This time we can have the images of not the entire, if you can give the image. How many can I take? The email address for? Yeah, the list can.
Shade.
Are you in for the schedules or not?
We are in for the schedule.
We can work to submit a list of schedules. We can agree on those four. Whether this or if you are not, something you can even submit. So that at least this one may not be on Friday. But this, and they are different, you have some. This is mandatory. So we can appeal the schedule.
So we can come for the service.
we can solve for the shape as my Lord.
The next one, yes.
You can give us a interpretation, my Lord.
Let's get a schedule now. What's
Kali, koti wetu